Hi, Nick Dogan, North State Law, where we safeguard your professional license so you can get back to business. I am the owner and founder of North State Law. So today we're going to talk about the North Carolina Physical Therapy Board, better known as the North Carolina Board of Physical Therapy Examiners. So we want to talk about the investigative process, the complaint process, whatever nomenclature you prefer. Essentially, what happens when a complaint is filed against a physical therapist in North Carolina. So initially, the Physical Therapy Board will start the investigative process that involves the investigative committee that is made up of the executive director, in addition to a board member that is assigned by the chairman of the board, or chairperson of the board, I should say. And their obligation is to determine if probable cause exists to find out if there is any legitimacy to the complaint. Now, the executive director and the board member that make up this investigative committee, they will be assisted by the attorney for the board, and in addition to the investigator, one of the investigators for the board. So, during the course of the initial part of the investigation, if the board investigative committee finds out that there's not enough probable cause to believe that the complaint has any legitimacy, then they will dismiss it. If they don't, and they find that probable cause exists to believe that there is legitimacy to the complaint, or that the complaint has enough probable cause to go forward, then they will proceed and they will have what's called an informal meeting with the licensee. Now, this is just the initial part of the process. This is the first opportunity for the licensee to present any documentation to the board, anything that they want the board investigative committee to consider before the investigative committee comes up with an initial recommendation. So you go through that, and the recommendation could be, all right, well, after we've actually looked at all this other stuff that the licensee has, now we're going to dismiss it. Or they could say, no, we do still feel that there's something here, and we're going to implement this penalty. It could be a written warning, it could be a public discipline, it could be suspension, it could be revocation. So there's a lot of different things that they could come up with on a recommendation. Now, if you get back something on a recommendation after going through the initial informal meeting with the investigative committee that you don't like, say you get a public reprimand with a fine, and you're like, well, I don't want to take that. That's going to be out there on their board's website, and it's not going to come off. I don't want that. Then you have a couple options. Within 20 days of getting that, you can request to speak with them through informal communications, basically negotiate with them and try to get something less. And what that would look like is presenting as much mitigation as you possibly can. Letters of recommendation. If this is an issue involving any sort of substance use or abuse, then show any rehabilitation that's been done in that respect. In addition to potentially some other mitigating factors, which we won't get into here. And then you negotiate with them through their attorney. If you're represented by counsel, then your counsel will negotiate with the board's attorney and try to come up with a better outcome for you. The other option is to request a contested hearing. That's always an option in cases like this. You could request a contested hearing and then also request to have, try to negotiate with them. That happens a fair bit where, hey, I want to have a contested hearing, but you're also still trying to work things out with them. That's not uncommon for that to happen. And then if you can't get anything worked out with the board and you can't come to a resolution that you're happy with, then you can always have a contested hearing, present your side of the story, say, hey, either A, this didn't happen, and here's my evidence showing that it didn't, or B, here's mitigation showing why the penalty that you're recommending should not be implemented because it's not as bad as it appears on first glance or even second glance. So that's the long and short of the process. If you have any questions, please check out my website. It's northstatelawfirm.com. We have a ton of blogs on there. We also have a lot of information on our YouTube channel, so check out information on there. If you still can't find what you're looking for, then please give my office a call. It's 919-521-8810 and speak with a member of my staff. via a free 15-minute discovery call. I hope everybody has a fantastic day, and thank you so much for doing what you do. Bye-bye.